Okay, next we're going to have a discussion on ethics and sunshine laws, open meetings and records. We have with us today the law director from the city of Piqua. Her name is Stacy Wall. Stacy has been there at Piqua for 11 years now, and she was also an assistant city solicitor for the city of Cincinnati before going to Piqua. She's very experienced. She represents Piqua at the Enverma and has been involved with many things to keep up on top of this. And I'm sure you're going to find this very interesting. Even if you don't, please pay attention to it. This is what Mark was indicating before about the legal stuff. This is the stuff you want to make sure you're doing right, okay? If the rest of it you can kind of muddle through, but this is the kind of stuff that can get you in real trouble if you don't. So anyway, let's welcome Stacy.
Hello. You received several handouts, so you should have all received the PowerPoint for your book. And I am talking about the Sunshine Law today. And so lucky for you, it happens to be Sunshine Law Week. So one of the announcements or papers you were handed is from the Attorney General. That announcement came out on Monday. The yellow book is what it's referred to, is the manual of all of the sunshine laws. They do editions every now and then. So this announcement that you have in front of you is that they put out a brand new version. You can call the Attorney General's office and request a free copy, or you can download it for free from their website. It's very informational, very useful. It has way more in there than you will ever need, but it is very helpful to have if you would like a copy of that. And again, that announcement was to tell you that there's a brand new version out there. So I'm going to talk to you today about the sunshine laws, which includes ethics as well as public records and Open Meetings Act. And so the second sheet I gave you, individual sheet, has about 8 questions on that. If you want to take just a minute and read through those and put down your best answer, and then we'll go through those as well as we go through the presentation. So we're going to start with the public records and open meetings. That is all in that yellow book. That's considered together the sunshine laws of the state of Ohio. The purpose in Ohio, we have one of the most open record states there is. And the purpose is to allow access. We want to be transparent as a state, as a government, as a city, as a village. We want to be able to allow people to access our records to show that we're doing everything we're supposed to be able to do. On the government side of things, for the ones who are actually producing those records, it seems a little beyond what we need to do at times, but that is the law of Ohio, and so that's what we need to comply with. If you don't comply with those laws, there are very strict penalties, and that's why we go through this training. Years ago, the Attorney General's office got put by law in charge of actually training all elected officials. And so now it's a mandatory requirement that once during your term, you are to receive mandatory training from the Attorney General's office. And the caveat to that is your clerk, your city clerk, city council clerk, whatever that position's called, is permitted to attend that training on your behalf. And that person would submit the records to the Attorney General's office that you've received the training. You will have to do this if you're reelected again, so once each term. That's the Attorney General's information, which is also in your handout there. So the Public Records Act is under Ohio Revised Code 149.43. That number is ingrained in my head. It's sort of the Bible for what we follow for the Ohio Public Records Law. It only applies to public records. So there's a definition that follows as to what a record is, but it has to be a public record in a public office. So a lot of that may seem obvious. We're the city government. We are a public office. However, there's a lot of entities within that government that also are considered public office that probably have public records requirements. For example, a lot of you have community organizations called in Piqua, it's the Piqua Improvement Corporation. That board has city officials sitting on it, city employees, and volunteers, citizens sitting on it. But they receive funding from the city. They make decisions on behalf of the city as to what will happen with property. That's considered a quasi-city government function, and so they would be under the public records law as well. Public office includes basically any institution in the state of Ohio that's dealing with the government and exercising the rights of the government. But when we get to Open Meetings Act, public office does not mean the same thing as a public body. So we will get into that. Under the revised code, it is specifically defined, and the definition is considered a three-part test to be a record. To be a record, it doesn't matter what form it's in. A lot of people believe once they receive the hard copy and they dispose of that, even though they scanned it into their computer, it's not a record they're producing. It doesn't matter what the format is, whether it's a text message, a voicemail, whatever the content is, that's what determines a record is. Then the second part is that it's received by the government or it's created by the government. And the third part is it has to document the organization. What is your government doing? And that makes the content a public record. One of the really important challenges that's been coming up is, like everything, electronics. So the governments are being challenged right now on emails, text messages, those types of things, because they're very hard to maintain a lot of the times. If you're individually at your computer and you say, I already completed that, you hit delete. The question is, did your government, did your city maintain that email so that when there's a public records request, you can still produce it? So you need to check with your individual IT departments to see if they have some type of backup software. And there's a difference. Even if your computer is backed up, that doesn't mean IT can actually access that email. So you need to make sure from your own city, what is the process, what works, how's it maintained, and how's it accessed? Is it archived? A lot of times when they say it's backed up, it does not mean it's archived, which means can you access it? Text messages are a whole new battle. And text messages themselves are individually on phones. Very few governments are maintaining them as a government. They're relying on the individual user. One reason is cost. It's very costly to maintain all of this data on a software system. And the second reason is the government has all these phones all over the place. They don't know what's going out there in text messages. I have been with Piqua over 11 years, and from the beginning I've carried two phones, one personal, one private, or one, for work. I always encourage people to do that. As soon as you start using a personal phone or a personal computer for work, you've now exposed your personal phone and computer to a public records request. So you want to keep that as independent as you can. And I think in today's age where we so easily text, it's very hard for employees to remember to keep them separate. But you need to know, again, from your IT department, are they maintaining text messages? Are they maintaining emails? Are they maintaining voicemails? But if you're using one device and it has two separate numbers, it would not expose your personal number if it's clearly separated out by a business number. The other thing that's been included, again, why you should ask your IT department what they do, is under emails especially, there's what's called metadata. You don't see it, you never even know what it is, but it's the background of that email through the computer system, and those have been made as public records requests. And so you would need to make sure that if you are deleting emails, one, they're going to be able to be maintained or pulled up again by IT, and that they're within your retention schedule.
So I have a Google Voice number also, and I guess I'm the director of IT at Antioch College. It's my real job. Google Voice, can ring to 5 different numbers. So really, I think not to just brush over that question. I think it's important to understand where the calls eventually end up. Google's sort of like a broker of the call. But the question is, where does the call really end up? So you could call my Google Voice number, but it could be up to 5 different places where the actual message can land. So I think you want to be more careful with that. Just because they're 2 separate numbers.
Can you decide which number it goes to? Okay.
Yeah, you can pick 5, all 5, or any one of the 5 different places. As long as you're telling Google, to hold on to the message as opposed to letting it land on your phone. Yeah.
So it sounds like that is an option, but check with your IT department. We had an issue in Piqua where for a little while we had commissioners with personal email. They didn't always check the work email. So IT was routing the work email to their personal email, which I think you could do. However, the problem we ran into was when they responded, it did not come back from the work email. It still came back from the personal email. So we had to discontinue that because now we've exposed the personal email to that public records. So it is tricky. When determining whether a record is a public record, there are certain parameters. Again, it's the content that defines if it is a record or not. Employee notes are typically not records if they're for your own purpose. If you're writing them down to recall something, to reflect upon, that will not be a public record. However, if you're in a meeting and you make a photocopy of your notes and you pass them out to everybody in the meeting, you've now made that a public record. So normally in your capacity, probably what you're doing is it's just a note so when you go to vote, you remember something or you want to write that down to follow up on. That's not going to be a public record. This also reflects, remember, the public versus personal use. One case we had was the employees would do a golf outing. You had to use personal time or vacation, but it was for the employees just to get together and have a day. Well, the person in charge of that, getting everybody to golf, used his personal computer at home. The newspaper made a public records request when they found out public employees were golfing, and so he tried to get into the personal computer to get all of this data. We were able to show he was not working at home. This was purely personal. They were on comp time, whatever it may be. But you do have challenges in trying to get the personal computer. The last step for the public records request is after you've defined that it is a record, you have to know if it was maintained and was the agency required to keep it. If you were required to keep it, you are probably required to produce it. And there are a lot of rules about what gets produced and how you do that. Anybody here from finance department or deal with a lot of the finances? I would say that group is the group that gets hit the most in terms of what is a record, because there is a big request out there now from private companies asking for lists all the time. What is the list of all your vendors? What is the list of your top salary producers? We don't keep lists. We don't maintain lists. However, there is current case law pending, which we will be watching because it defines that issue. Are you required in our today's age that you can hit a button and you'll easily create a list? Even though you don't maintain a list, will you be required to produce a list when it's just hitting the button in your computer system? And that is an issue the Attorney General's office is in litigation right now over, so we'll be watching that. I have advised the city of Piqua we don't need to produce it because we don't maintain lists, we don't keep lists. However, They have decided to produce them because they said it really is easier to produce a list from hitting that button on the software versus taking all the documents you need to produce and redact what they're not asking for. So for virtue of ease in producing the request, they've decided to produce a list. Once you produce a list, what have you just done? You've created a new record. So now you need to maintain it. And you need to make sure that's on your retention schedule as well. In producing public records, there are many exemptions to that. Some are obvious: social security numbers, income tax info. EMS data hardly ever gets produced because it's all protected by HIPAA. Juvenile court records, those are always redacted. Rarely can you get that type of information. Infrastructure and security records, and personnel, safety personnel's home addresses. So your police and fire, you cannot produce those. This is not a complete list. That complete list is contained in your yellow books if you get that, but rarely will you need to produce something because you're not the keeper of the record. The keeper of the record produces everything. So that will probably be your city council clerk, whomever you're working for, that clerk is responsible for the production. Really, you just need to have a general idea that there is stuff that does not get produced. Because once that person is producing it, it's their job to review it, to redact it, or there could be liability. But they are producing it on your behalf as the record keeper. You wouldn't have to individually worry about ever producing anything. If you get a public records request, you should hand it off to whomever is to produce it. You should not try to do that on your own. Any person can make a public records request, but person does not mean individual. That's why we get all these private companies making requests. The city of Piqua is a member of AMP Ohio, so we have a lot of electric issues, and we get requests all the time from those public interest groups out there against the environment, those types of things. Every month we get a request from them saying we want all your invoices. So those type of issues, we have to respond. And even though they can submit a public records request for the same information, there's nothing that prohibits really how many they can do, other than right now the law, they've tried to help cities a little bit, and I think they can't make more than 10 records requests within a month. And I just met with the state legislator about 2 months ago over that issue, and I said, I appreciate you trying to help us, but 10 records requests doesn't help us when each request is 1,000 pages. And I think that point was missed when they tried to write the legislation. There was good intent there, but that would work if each request was a few pages. It doesn't work when each request is multiple pages. The problem in the law really is this reasonable time to respond. The other problem is there's really no way to define that. So if the request comes in and there's a hard and fast 5-day response date, that'll be great if it's 3 pages you're producing. But if you're producing thousands, which we often get, there's no way to do that in 5 days. So there's no way to define it in the statute, a fine number on the days to produce. So that's why it's reasonable amount of time. The problem with reasonable amount of time is it doesn't matter what your job is. It doesn't matter how busy you are. It doesn't matter that you're on vacation next week. It says you have to produce it. The townships in particular are really, really struggling with this because they probably have 1 employee. So instead of getting their work done, they are forced to work on a public records request, and then the work doesn't get done. But if they don't produce it, then we've seen litigation. So that's where we really struggle. The other part we struggle in is really getting the same request over and over again. A lot of it comes in when you have building code violations. Those people love making the same request on the same piece of property over and over again, and each time you have to produce it. There's nothing that says you don't. So until they rewrite the law, we still are producing. If you do not respond and you don't produce, there is a right for a mandamus action against the city or whatever your government is, and there is major financial penalty for not producing. It's always a best practice when you receive a public records request to respond in writing, say, I've received it, I intend to fill it, I'm working on it. Then if you can't respond to it, you need to put that in writing. It's actually a requirement under the law that you respond in writing saying why you cannot fill that request. There are a couple of issues why you can't fill them. One would be because the request is overly broad. So you would put in writing, your request cannot be defined, it's overly broad. We do see a lot of those requests from individuals, and a request such as that would be, I want all emails from the law director since she started work. You can't produce that. It's not a defined records request. So you are permitted to write back and say, if you would like to put a parameter around this, we would be happy to oblige to your record request. The other reason you could have them put it in writing is if you can't understand the request, which you often get as well. And that normally comes with police department requests when they want a certain case. We don't understand what they're asking for. You are not permitted to require them to put it in writing, or there's a fine, but you are permitted to ask if you would help, if that would assist in filling the request. The person can deny and say, I don't want to put anything in writing, and then that's it, that's done. But you can request it if it would assist in filling that. The other duty that comes along with public records is the maintaining the record. There's a lot of requirements for that, and one is that it has to be maintained in an orderly fashion. One, that's going to help you when it comes time to produce the request. But the other reason for that is somebody who makes a request does not have to get paper. They can come in and say, I would like to make a public records request to review your file. At that point, you are required to pull out the file and they can go through it. It's not a paper production every time. So if you don't have an orderly system for your files, you have impeded that requester to get what they're looking for. The second part is that there's a records retention policy for every department. And the state of Ohio has done an excellent job in producing examples of record retention policies. A lot of them have to do, they're based on content and based on your department. City councils maintain records forever. Nothing is ever deleted, destroyed, because it's the actual laws and records of your city. But there's a lot of things that are considered for administrative value. So that can be deleted, again, if it's on your record retention policy, basically as soon as it is of no longer value to you. The best example of this are voicemails. Once you've returned a call, you don't need it for any further purpose, you can delete it. But until it's returned, you have to save that voicemail. Another example is emails you get routinely just to schedule things. Once it's on your calendar, once it's been scheduled, the meeting's over, you no longer need it, you can delete that. It's of no longer administrative value. But your departments will be very specific on those records. Everything is kept on there. Once you meet a record retention requirement, you can destroy the records by submitting the required forms, and they go to every government has a records commission, so you want to find out who's on that. But the requests get submitted to the records commission, they approve the deletion, and then you can destroy the records. There's a lot of forms all produced by the state, so nothing you have to do on your own, you just get the form. The public records policy of each department is required to be posted so the public is aware of it. So if you've never seen it in your government, you may want to ask for a copy of it just so you're aware of it. But each department is required to have that available. When you produce the records, the most important thing is that it is produced in whatever form the requester wants. Most requests are now electronic, so they pay nothing. You're only permitted to charge a very minimal cost, which is the actual cost of the paper, so 5 to 10 cents. Most governments have a policy that the first 20 to 25 pages are free, and then you pay after that. But again, it's 5 to 10 cents a page. You cannot charge for time, and that's why we have a lot of issues with administration. It doesn't matter what your time is involved in filling the request, you don't get to charge for that. So it's purely the cost of the paper that you charge for. The requesters now, especially on these large requests, send it via email, scan it in and send it to me. Frankly, 5 to 10 cents isn't covering anything, but now it really takes twice as much time to do these electronic requests because you have to produce it, you have to review it, you have to redact it. But now since you're scanning, you typically have to make a photocopy of that before you scan it, and then you scan the request. So they're extremely time consuming. But there's nothing you can do except fill the request. Under record retention, you really just need to know the policy. And again, if you don't know, which shouldn't apply to you because you probably won't be the one producing the record, just make sure you check your policy and ask the commission, the Records Commission. The city itself can be penalized up to $10,000 for destroying records without authority. So there are severe penalties in place on public records, and that's why it's so important to understand the laws. A lot of this comes in litigation. The best thing that happened was in 2011, there was a person going around the state specifically requesting 911 reel-to-reel tapes, knowing they had been destroyed because that was from, I don't know, 1970. But this is good law, right? But it's probably fairly new. We have record retention schedules now. We didn't have it in 1970. So he was able to file a lawsuit in every case saying, you can't produce it and you destroyed it without authority. I now get money. Well, the state caught on to this and it did go to court. And finally, the Supreme Court said, you truly have to be an aggrieved person before you're going to get the money. You had no purpose in asking for 911 tapes, reel-to-reel tapes from around the state, and so you were not aggrieved. So that has made a huge difference because we did get these requests all the time. You see it in cycles. So that guy did it on the 911 reel-to-reel tapes. We saw the next thing was on your sign codes. They started making all kinds of requests for those. So it kind of goes in cycles, but with that Supreme Court decision, it really has made a difference that we don't see that as much. Because if you had a case, say a sibling, a family member got harmed in a police case and you really needed that 911 tape, you're now aggrieved if they don't have it. But just to go around the state saying, I'm going to collect from that government, you're not aggrieved. Yeah, right. It's a moneymaker. The second part of the Sunshine Law are the open meetings, and it applies to every public body. And in the beginning, I said the public government isn't necessarily the same as the public body. So there are 2 public bodies in Ohio that are exempt from open meetings, and they are grand jury, not permitted to have anybody in there, and the other one is the Ohio General Assembly. That is not an open meeting, which I find ironic. But it's not. So they are exempt from that requirement as being a public body. There is an exception for executive session, and you have to meet those specific reasons for executive session to go into that. During executive session, it has to be by roll call vote. Those are the parliamentary procedures, and if you don't do a roll call vote, it basically says you're not in a valid executive session. So make sure your clerk during your public meeting does a roll call, a first, a second roll call vote before you adjourn. The case law has also come out in the last few years saying that not only can you say we're adjourning into executive session, you have to specify the reason very closely. This defines a public body, which is in your outline. Personnel matters. That would go into executive session. You cannot say we want to adjourn into executive session for a personnel matter. That's too generic. You have to define it to say, I move to adjourn into executive session to discuss the compensation of the city manager. Something more specific, so it's defined for the public. So under those reasons, you can adjourn into executive session. It should be listed on your agenda during your meeting that you will be adjourning into executive session for that reason. If you have a charter in your city, it should include the reasons for executive session. If not, it's definitely defined in the Ohio Revised Code. Okay, again, the public body does include those improvement corporations, all of your park boards, committees, all of those are included in public bodies, so those are subject to open meetings. In determining whether it fits that definition, the courts look at what is the manner in which that group was created, the name, the official title, the membership composition. Is it city employees, city council members, and citizens? Is it citizens only? Do they never report to city manager or the city government? Those types of issues. Are they making decisions? Are they deciding? For example, your park board probably says, we voted, we want a $1 increase in golf fees. That's a decision. So they're going to be subject to the Open Meetings Act. And again, who are they reporting to? Who is advising them? Most of your committees and boards are being advised by your city government, probably your law director or the county prosecutor. And they normally have a staff liaison on there. If there's a staff liaison, you're going to be subject to the Open Meetings Act. Does anybody here govern a cemetery? Okay, so the cemeteries are part of that. We have a cemetery, it's a union cemetery created jointly by the city and the township, but I legally advise all those cemetery boards are public open meetings, and they have to maintain their records. Meeting is probably the trickiest definition there is, even though it's a very simple word. We all know what it means to meet, but if it's prearranged in any form, that will consist of a meeting. Where council members get into the most trouble is email. You cannot round robin by emailing each member individually to say, how are you going to vote? This is what I'm voting. This is what I think. You cannot go door to door. When I worked in Cincinnati, this case took place where the council members all had offices in there, and somebody went down the hall, door to door, asking for the vote. What are you going to do? You can't do that. That's avoiding the public meeting. And they did have litigation over that where the court said, yes, you violated the laws. You have to have an open meeting. You can't prearrange a decision, a vote, because it all has to be in the open.
Well, being a congressman.
General Assembly is exempt, remember? So this happens very often, and I would say probably maybe the city of leaders, the city managers aren't really aware of it. But as city council members or trustees, whatever your title is, please be aware that you cannot participate in this type of action. So if somebody emails you, a council member emails you and says, hey, I'd really like to see a vote on this. What do you think about if it goes forward? That's okay. You can say, I'm in favor if you want to bring it up. If he says, hey, I want to see this motion passed, who's going to second, and is everybody on board? That you can't do because you're making a decision of the government outside of an open meeting. The other definition that really matters on a meeting is it has to be more than 2 people. So if there's 5 people on your commission or council and 2 of you stay after the meeting and discuss a lot of things, that's okay. But as soon as 3 people are there, not okay. So it's the rule of 2. 2's okay, more than that you cannot do. The one thing you can do with more than 3 people is a lot of events have everybody there. So if it's a chamber dinner, the United Way is holding their ceremony, whatever it is, and all the commissioners are invited, all of you are permitted to attend. But don't be standing in a corner talking by yourselves. Mingle with the crowd, go for the purpose of the event, and you can attend. So if you have two city council members,
Okay, you got a city council of 7 people.
it doesn't matter, it's two. So if you have 3 people, 2 people are okay, more than 2's not. They don't want more than 2 people discussing public business. And you may not be, you may be,
Not take action unless there's a quorum. In this case, if it's a 7-member body, you'd have to have 4 people.
but you're not taking action anyhow, because you have to be in session to actually vote or do whatever you need to do. But you are doing the debate outside of an open meeting. The problem is appearance of impropriety. One person's there innocently just to observe, but because you have 3 there, the public cannot know they're not going to discuss public business. So that's why the law's in place. You could have 3 people saying, hey, we all love the Reds. We're going to the game and drinking a beer. But the public doesn't know you're only watching the Reds and drinking a beer. We can't know that, so that's why the rule's in place.
So you can't have city council night at the ballpark? I'm joking.
Well, that's a very valid question, though. You can if it's in a different format. So, for example, our business chamber holds after hours all the time, normally at a business. But one time in the spring, they hold it at the Dayton Dragons, and all the commissioners are invited. They all can attend that because they're going so under the
Just don't talk business.
don't talk business for sure.
How can anyone prove what you were talking about?
There's always an allegation, doesn't mean there's truth. However, there's a lot of technology today that gets everybody in trouble. So, for example, there's a group out of Cincinnati that makes a living on challenging open meetings, and they have an app on their phone. And they go to these meetings and they put in the app what's going on, and it sparks litigation. So I don't know all the specifics of that, but that's the problem. You're now under an allegation. So probably half of litigation is that way, right? Everybody's being sued, and I have a perfect example. I'm in one right now. I'm actually named. I'm also the prosecutor for Piqua, and a guy filed a writ of habeas corpus. He named Stacy Wall as an individual party as the prosecutor. I'm not the prosecutor. It was another case. It was out of Troy, and Katie Wall is the prosecutor. But I'm still in the case, and I had absolutely nothing to do with it. So it's the same premise. You may innocently be drinking your beer. You may innocently be watching the Reds, but there's an allegation, and now you're in a position where you have to defend that. The standard is clear and convincing. So if they say you're at the bar, they call the bar and say, we want the video of your bar. And they show the video, and there's all 3 of you sitting at the bar. That's already against you. So proving the discussion is a much harder issue, but it's a challenge, and it's just a challenge you want to avoid. Let me give you an example. Our chamber does an annual dinner, and all the council members sit at the same table. That's okay, because you're there for the chamber for that purpose. And remember your audience. Normally the ones challenging you are Joe Smo off the street. The ones at the chamber are the business members of your community. They know why you're there. You're acknowledged as being the council member present of your city. So it's a different type of atmosphere. So while you should be careful about it, remember your audience. Remember where you're at. If you're at a chamber dinner and you're all sitting at the same table because there are assigned seats and they put all the council members together, you're going to be okay there. Just don't start discussing the city agenda for the night. But you can sit together. It's a little bit of common sense, even though it's hard. Yeah. Go ahead.
Does that exclude the mayor?
That depends on your city. My mayor is also a council member who votes. Some mayors don't do anything except, well, even if your mayor only votes and vetoes, I would not have him there because you have more than 2 there. If he's part of that decision in any capacity or could be, then you would be violating the rule. Two of them are assigned to the Planning Commission. They are there for the purpose of being assigned to the Planning Commission. If the third one shows up, they're not assigned to that Planning Commission. So somebody's going to argue. Again, look at your audience, who's going to challenge, but this is the way the law is written. You don't want that third person being challenged saying most things from the Planning Commission, then go to your council. So are they there only for their own information, or are they there to discuss with the other two council members what's going on?
But what if they're not assigned? What if they're all there just to see what's going on in the meeting?
That's where you have the challenge. You could be there just for your own benefit. But if somebody sees the three of you there, and normally that person comes in and sits with the other two members he knows, you now have three members together who looks the appearance of impropriety, the appearance that they would be discussing what's going on at that Planning Commission, because why else are they there? It looks like, why else are you going to be there unless you want to discuss the business of the Planning Commission, even though it's an open meeting? So those three members, the appearance of it is they're going to discuss business outside of their public meeting. So it's not the fact that they're at a public meeting, it's the fact that they're outside of their public meeting where they make the decision.
Just go have dinner with your wife and forget about it.
Good idea.
Avoid the
Yes, and that's what the whole ethics issue is. It's the appearance of impropriety. So if you can remember that. What I'll do is I'll do a summary and send an email to Yolanda, and she can email everybody so everybody's clear on that. And I know I'm out of time and I'm not even halfway through. So just real quick, I want to mention the ethics in Ohio are extremely serious. If you have any question, if you have a conflict on voting on something that you need to ask your law director for an opinion, you then probably on the safe side should disclose during your public meeting if you do not have a conflict, but people are still aware. For example, we have one commissioner who's employed by a business in our community that often has things on our agenda. So everyone's aware of that. So if you know there's no conflict, you might want to say, I've asked for a legal opinion, I do not have a conflict on this. If you do have a conflict, you cannot participate in the discussion, the debate, not just the vote. You have to recuse yourself from all of it. If you have any questions about that, the website for the Ohio Ethics Commission is extremely helpful. In your handout, there's a lot of sites to their website. They have videos on everything you can watch. They give opinions all the time about conflicts and ethics questions, so I would encourage you to look at their website. I'm sorry we didn't cover it all, but I will follow up with Yolanda so everyone knows what's the Rule of Two kind of issue. Thank you.
I'd like to apologize to Stacy because, again, what we're trying to do is probably fit 20 pounds of potatoes in a 2-pound sack. If you feel like you'd like to know more about this, if you'd like to get more training, pass that on to your city manager, pass that on to us, and we can provide a more in-depth training opportunity for you all.